Yeah. Please continue.
I'll speak only for 15 minutes. Then
Yes,
thereafter, if any questions are there, they can ask either in Telugu or English.
Yeah.
Civil courts, civil matters range from property disputes to breach of contract to diverse cases. I was referring and telling to you about the principle that's called Roman principle ubi jus ibi remedium. That means for every wrong, the law provides remedy. So law contemplates that for any wrongdoer, particularly when he commits a civil wrong, whether it is done, that wrong is committed by individual against other individuals, or entity committed by an entity against an entity or against an individual, then the aggrieved party can approach the court in order to provide remedy for the civil wrong committed by that person. So for every wrong, the law provides remedy. We need to understand what do you mean by civil nature and where from we are getting civil courts and civil cases, these words. We have two laws. For civil side, Civil Procedure Code. This is the basic law. Civil Procedure Code deals with the procedure which is contemplated to follow by the civil courts unless and otherwise expressly barred or impliedly barred for proceeding under that particular law. Criminal side, Criminal Procedure Code is there. So far as recording of evidence is concerned, there is a law called Evidence Act. Civil Procedure Code, Criminal Procedure Code, Evidence Act, these three are actually during the British region in 18th century, these laws are made. We are following the same laws but with necessary amendments. So in order to understand what are the civil courts and what are the civil cases, we have to understand section 9 of the Civil Procedure Code 1908. That says, unless expressly or impliedly barred by any other laws in force, civil courts have the jurisdiction to try all suits of civil nature. So by understanding that dispute, you must feel or come to a conclusion that a civil wrong is committed by somebody against somebody. If the dispute is of civil nature, unless expressly or impliedly barred by any other law in force, civil courts are having jurisdiction, both virginal or appellate side jurisdiction, to try those cases and provide remedy for the civil wrongs committed by any individual or entity against the person who approached the court to implement his rights, seeking for a remedy. So civil courts are having jurisdiction to try all suits of civil nature. By looking at the dispute, you must understand that the nature of that particular dispute or case is of civil, not criminal. Then you can go to civil courts. Section 9 of the Civil Procedure Code 1908, which is there to have a procedure for conducting trial and give a decision in that particular dispute. It says about unless expressly or impliedly barred by any other law in force, civil courts have the jurisdiction to try all suits of civil nature. The Code of Civil Procedure, we call it as CPC 1908, governs the procedures to be followed by civil courts in administrating civil cases in India. As a matter of fact, every suit must be instituted. Instituted means filed. Suit has to be filed before the court of lowest jurisdiction, the municipal courts. Upon institution, it is decided whether the respective court has got competence to try the case or not. So, if any civil wrong is committed, then you have to approach the court and file a case. That case is called as suit. Case is called as suit. In criminal side, we call it as criminal case. In civil side, we call it as civil case. But the name of that civil case is termed as per procedure and law as suit, S-U-I-T, suit. So as a matter of fact, every suit, that is for whenever a civil wrong is committed, it must be filed or instituted before the court of lowest jurisdiction. What is the lowest jurisdiction on civil side? Municipal court. Above it, subordinate courts, called as senior civil judge court. Above it, district court. So the lowest court is municipal court. So you have to approach for committing any civil wrong the municipal court, and upon institution of a case, that is a suit, it will be decided whether the respective court in which that case is filed has got competency to try the case. What do you mean by competency? Competency is two types. One is pecuniary jurisdiction. Second is territorial jurisdiction. What do you mean by pecuniary jurisdiction? Pecuniary jurisdiction means what is the value of the particular dispute. Suppose if the dispute is for 100 rupees, then basing on that value of the suit, you will decide about which court you have to approach. That is the first principle. Second principle is territorial jurisdiction. That is where the dispute actually has arisen. Place. Suppose you are working at Hyderabad and staying at your native place, Nellore. Dispute has arisen at Nellore. You are working at Hyderabad. So what is the territorial jurisdiction? Rather, the area where that dispute has arisen. The dispute has arisen at the Nellore. So you have to approach the Nellore court, Nellore Municipal Court, because the civil wrong is committed at Nellore. That's why you have to approach the district municipal court at Nellore for getting a remedy for the civil wrong committed against you. If that court is not having jurisdiction, due to two reasons. One is pecuniary jurisdiction, that is value of the matter. Suppose district municipal court is having jurisdiction only about the disputes which are worth about 5 lakhs, let us say. If your dispute, civil dispute or civil nature dispute is more than worth of 5 lakhs, then you have to go to next high court, next higher court. What is the next higher court from municipal court? Is senior civil judge court. Then if the value is more than the value of a suit over which the subordinate court, that is senior civil judge court, is having jurisdiction, then you must approach the district court. Depending upon the pecuniary value and the place where that civil wrong is committed, you will decide about which court is having jurisdiction. So unless and until you understand the nature of the suit and value of the suit and also the place where the wrong is committed, we can't decide about to which court we have to approach and where from we will get remedy for the civil wrong committed against you. So whenever a civil wrong is committed, you must first look at the value of that particular dispute, and then whether that dispute is of civil nature or criminal nature. Then where is the place where that civil wrong is committed? After these three points are looked into, then you will understand about to which court you have to approach for getting the remedy for the civil wrong committed against you. At that time, again, you have to see whether there is any express or implied provision under any particular law not to approach the civil court, and you have to approach only tribunal. So first you will look into the value of the suit, and secondly, what is the nature of the dispute, whether it is civil or criminal, and then third is where that particular civil wrong is committed. After this, you will see whether any particular law or act or GO prohibits the civil court to decide that particular case. Depending on all this, you will decide the court to which you should approach for getting the remedy of a wrong committed, civil wrong committed by any individual or person against you. So, civil procedure court, we must understand, it governs the procedures to be followed by civil courts in administrating civil cases in India. Then every suit must be instituted before the court of lowest jurisdiction, it is municipal court. Again, if the value is more than the pecuniary value of the jurisdiction of that particular municipal court, then you will go to next higher court, and depending upon that value, you will decide whether the respective court has got competence to try the case or not. We have to, let us see, as we discussed earlier, about what is the hierarchy of civil courts in district level. I told you in district level, first district court is there. The court of district judges is the highest civil court in a district. Whenever you go to any courts in lower level at district, what is the highest court? District court is the highest court. It exercises both judicial and administrative functions. The district judge combines the powers of trying both civil and criminal cases. Hence, district judge is designated as district and sessions judge. Why the designation is given? Because he decides both civil and criminal cases. With this, I end here. We will discuss in next class about the civil court hierarchy in districts. Thank you. If anybody is having any doubt, they can ask.
Yeah, please ask if you have any doubts.
Sneha, Vishnu, you should note down all the points because he has given a very detailed notes. In fact, I do not know some of the intricacies, sir. Today I learned most of the things because the difference between a magistrate and the jurisdiction and all these things. Anyhow, it was very interesting. Please ask some questions. Sneha, Vishnu, Vikram, have you...
Free అడగండి తెలుగులో అడగండి ఇంగ్లీష్లో
అడగండి కావాలంటే ఇబ్బంది లేదు.
మీకు ఏ డౌట్ లో అడగండి.
జ్యుడిషియరీ గురించి నీకున్న డౌట్స్ సార్ని అడిగి తెలుసుకో.
సార్ క్లాస్ మధ్య జాయిన్ అయ్యింది సార్, కొంచెం అంటే రాజమండ్రిలో వచ్చింది సార్.
నీకు మామూలు నీకు అసలు జ్యుడిషియరీ గురించి నీకు ఏమైనా డౌట్ ఉంటే అడుగు. నువ్వు పాఠం వినాల్సిన అవసరం లేదు.
ప్రస్తుతంగా అయితే ఏం లేదు సార్, అంటే
రైట్ విక్రమ్, నువ్వు చక్కగా నోట్స్ అవి రాసుకొని సార్ని నెక్స్ట్ క్లాస్లో అయినా కానీ దీని గురించి, ఇప్పుడు సార్ క్లాస్ దీని గురించి తీసుకున్నారు కదా, జ్యుడిషియరీ గురించి, ఫంక్షనింగ్ ఆఫ్ జ్యుడిషియరీ నోట్ చేసుకో. సార్ నెక్స్ట్ క్లాస్లో ఈ వీడియో మళ్ళీ విని చక్కగా డౌట్స్ క్లారిఫై చేసుకోవాలి.
ఓకే మ్యామ్.
ఎప్పుడైనా అడగచ్చు, మీ సార్ని అడిగితే నన్ను అడుగుతాను, నేను చెప్తాను, ఏం ప్రాబ్లం లేదు.
రైట్.
ఓకే
ఓకే సార్. ఓకే సార్.
ఓకే సార్. ఓకే,
థ్యాంక్ యూ వెరీ మచ్.
ఐ విల్ టేక్ లీవ్ మేడం.
యా,
Thank you, sir. Thank you. Thank you.
Thank you very much.